really appreciate the opportunity to let you know about the work that we do when we're faced with these police use of deadly force investigations. It's very timely, obviously. I think we can all understand that. For weeks now, people around the country have been marching and protesting the current system. But as both our governor and our mayor have both said recently, what exactly constitutes reform is unclear. So I thought it would be helpful if we came together, and I'm so happy that Jeff and his fellow clergy members were able to pull this together on such short notice, and we got such a great turnout, to explain to you how the quote-unquote system works when we're faced with these types of investigations. This is an issue, as I mentioned, that is grabbing the national consciousness right now. But it's an issue that I've been grappling with for my nearly 13 years as district attorney. My purpose here is not to defend the current system. My purpose is, however, here to show you how we do it. You've heard some of that tonight by Superintendent Myrna. But also to explain to you the significant reforms that we've implemented over the last decade. They have not grabbed a lot of media attention, but they are meaningful, and they make our approach unique, I believe, in the United States. What you're going to see is noteworthy for a couple of reasons. First, there are not two systems of justice here in Boston, not one for the police and one for everybody else. How we investigate police use of deadly force is identical to the way we investigate homicide in our city. Second, there is a level of transparency here that I introduced more than a decade ago that most people find astonishing. Maybe you will too after the presentation. That transparency that we employ here in Suffolk County, not just in Boston, but in Suffolk County, is a great motivator for investigators who work on the fitted team. It's a leveler of rights and is a guardian of the truth. So I'm going to run through what I hope is an informative presentation for you. At the end, Superintendent Myrna and myself and others, I suppose, will be available as long as you want for us to answer questions. So in the spirit of that, let me get things going. So I've entitled my presentation, How Police-Involved Fatalities Are Investigated in Boston. First, let's have a 10-year review since 2004. So in the past decade, there have been no fatal shootings of unarmed individuals by the Boston police. Not one.
False.
There has not been one fatal shooting of an unarmed individual by the Boston police.
Lie.
Let me give my presentation. Maybe you can enlighten me and let me know who that individual was.
No problem.
In every case that officers drew their weapons and fired only after they were presented with an imminent threat of death or serious bodily injury. That's the legal standard for self-defense. There's another one over there if you want to take a look at that. There have been 8 fatal shootings by Boston police in the last decade. All of the deceased were armed. 6 of the deceased had loaded firearms. All of them who had loaded firearms pointed them at the police. 5 of them fired at the police. 3 police officers were actually struck with gunfire. 1 of the deceased attacked the officers with a knife in each hand. The officers had responded to a domestic violence call. When they got to the apartment, the victim of that assault was cowering in the corner when they were confronted with the individual in close quarters. In the apartment, he attacked them with 2 knives. 1 of the deceased had a replica firearm. He had threatened suicide. He was very despondent about his family's finances. And when the police got there, they responded to a 911 call that he was waving a firearm. When he got there, he actually jumped in one of the police cruisers and went off with it. That caused a chase to occur, and ultimately that cruiser crashed. The officers surrounded the vehicle. He pointed that gun at the officers, and they fired their weapons. That was the weapon that he pointed at the officers. The manufacturer described that weapon as the PT-80. Looks and feels like a standard high-powered pistol. So how do we reach the conclusions in those 8 cases? In none of those cases were the officers charged with homicide or any other crime. How do we reach those conclusions? Well, let me start off by explaining to you what my role is and what my responsibility is under Massachusetts state law. Under Massachusetts state law, and it's pretty much this way in every part of the United States, but here in Massachusetts, the Suffolk County District Attorney has the duty and the authority to investigate all sudden and unnatural deaths in the city of Boston, regardless of whether they involve the use of force by police officers. So any homicide, any sudden, unnatural, unexplained death, it's my duty and responsibility to investigate that. The district attorney or his law enforcement representative shall direct and control the investigation of death and shall coordinate the investigation with the office of the chief medical examiner and the police department in which the death occurred. Massachusetts General Laws, Chapter 38, Section 4. That's the law today. The district attorney, the 11 district attorneys, whenever there's any kind of unexplained and sudden death, it's our duty to investigate that. So the law invests with the district attorney a special check on police power because we are independent of the police. This is the system that exists in the United States. If it didn't exist that way, I'd work for the police department, I'd work for the mayor. They'd tell me who to prosecute and for what. But that's not the way it works in Suffolk County, that's not the way it works in the United States. I'll give you an example. We handle about 45,000 criminal cases every year. We dismiss about between 15 and 18% of those cases. So the police officers arrested and charged about 15 to 18% of the people out of those 40,000, and we dismiss those cases. Not because necessarily they did anything wrong or they did anything sinister. We concluded that there just wasn't enough evidence to prove the case beyond a reasonable doubt. But that's a check on police power. You know, the police can put handcuffs on you and bring you to court the next day, but then it's up to the district attorney to decide whether or not you will be prosecuted and for what. The district attorney's office is an independent agency. I'm elected by the people every 4 years. I don't respond, as I said, to the mayor. I don't work for the mayor, I don't work for the police commissioner, I work for the citizens. And I'm accountable to those people on these matters. The process. It is an independent investigation. Our role, as I mentioned under the statute, is to direct and control the investigation. Now, where do lawyers work? I think you know, courtrooms and law libraries. I mean, that's where we do our best work and most of our work. But when an incident like this happens, there has to be some police agency that handles the on-the-ground investigation. And Superintendent Myrna laid out for you who that is in Boston, the Boston Police FIDIT team. As he also mentioned, and we're called out immediately, a senior prosecutor from my office is on the scene. At the end of that investigation, and we are intimately involved in that investigation, directing, controlling, advising on the law, suggesting certain things be done, certain things be followed up on and the like. We have a transparent presentation of those findings. The complete investigative file is released to the family of the deceased and their attorney if they have one, and they often do. Facts, circumstances, and key evidence is then presented to community leaders and stakeholders for review. Some of you have been in those meetings that we invite right after we meet with the family. And I meet with the family myself, personally. The complete investigative file is then open for media scrutiny. So the Boston Globe, the Boston Herald, and any TV station, news agency in America can come in and review our file, and they have. And they've spent days doing it. In every case involving the fatal use of force, as I mentioned, a senior prosecutor from my office is immediately assigned and is out there at the scene and to lead a full and fair and impartial investigation. They are tasked with determining the facts and circumstances of the incident and whether or not criminal charges are warranted. It's always going to be the chief of my homicide unit, the first assistant, the chief trial counsel, the senior counsel, or our Deputy Chief of Homicide. Combined, I think they probably have about 120 years of experience as prosecutors. In Boston, I have chosen as my law enforcement representative a highly specialized and highly trained team of investigators known, as the superintendent said, the Firearms Discharge Investigation Team, often referred to as FIDIT. And these are the cream of the crop, I would say, the very best that the Boston Police Department has to offer in terms of its investigators. It's designed and deployed to investigate police-involved shootings, and the superintendent went over that with great detail. The majority of these investigators are drawn from the homicide unit. Since I have the statutory obligation to investigate sudden death, I insisted 10 years ago or so that I have a say in who was in the homicide unit. In fact, I just interviewed 3 young detectives today, and I recommended to the police commissioner that they join the homicide unit. So I have a say in who goes there. They're the very best that the department has to offer, I believe. They're known for their skills, their professionalism, and their integrity. But they always work under a senior prosecutor in my office. Why the BPD and why not somebody else? In Revere, in Chelsea, and Winthrop, if this were to happen, I designate a special unit from the Massachusetts State Police. But why not in Boston? Boston is one of the largest cities in the nation. It has the largest police department in New England. One of the largest police departments in the country. And if you travel around a little bit, not that I'm a worldwide traveler, but I've spoken to district attorneys all over the country, we really do have a highly trained and highly credible police department. They can bring, at a moment's notice, a very large number of detectives and uniform officers to a scene more rapidly than anyone else in the region. Why is that important? They can actually have hundreds of officers performing a canvass of the neighborhood, a line search, looking for evidence in a short amount of time. And that raises the amount and the quality of the evidence that we can recover during the very critical first stages of an investigation. Most police-involved shootings involve a district officer, a patrol officer, someone out there in a marked car who's responding to calls like those officers that I mentioned in the domestic violence case that I referred to, or their gang unit officers. But the FIDIT members are generally working out of headquarters, if not exclusively out of headquarters. They're in specialized units. They have a lot of experience. And in a department with 2,000 plus officers, it is highly unlikely that the FIDIT members know the officers that they are investigating. But they're asked that question, and if they do, they're off the case. Now, the closest thing that we have to FIDIT in the region is the State Police Force Investigation Response and Support Team. That's the group that would go out to Revere, Chelsea, or Winthrop if there was a police-involved shooting. The first unit, the first team as they call it, they bring a high-ranking state police response to the region to investigate all trooper-involved shootings and all small departments. Virtually every other one except Worcester and Springfield, if there was a police-involved shooting, the state police would do it. But since they come from all over, it can literally take hours for them to get to the scene and assemble it. In addition, they learned from Boston Police. It was the Boston Police FIDIT team that provided the model and the training for the first team. So under the direction of the assigned prosecutor, the FIDIT team investigates all aspects of the shooting. So the superintendent went over that in great detail. They collect, they document, they organize, they interview, they take statements. Everything is recorded. They go looking for audio and video and smartphone recordings. They look for publicly owned video cameras, privately owned video, shot spotter activations, ballistics, fingerprints, DNA, phone records, everything imaginable. It's their job to gather and document and organize and preserve. Why is that important? Because everything is documented, because every case is looked at that there's a possibility that this is going to trial, and we can never rule out that possibility. As I mentioned, if we have additional questions answered or avenues explored, we say so to the FIDIT team. Go Go out and do this, go out and do that. They're pretty good at what they do, but we also have, I think, pretty good at what we do, and we can help them along as well in their investigations. We've extended investigations that were otherwise complete in order to interview additional people that have been brought to our attention by the family. I sat with a family one time, was prepared to give them my rulings and findings, and they said, but you know, the police and you guys, you didn't talk to A, B, and C. So I turned to some of the fitted detectives that were in the room, and they didn't. So, okay, I'm not making a decision right now. I want you to go out and talk to A, B, and C, and they did, and A, B, and C had nothing to offer that was of evidentiary value. But I'm willing to do that. In fact, early on, the fitted team and my prosecutors meet with the family to say, do you have any information that we may not have? We don't want to leave any stone unturned in the investigation. At the conclusion of the investigation, all of the evidence is assembled. It's typically over 1,000 pages of reports and documents, multiple CDs of evidence and interviews and the like. And then it's our job to find out, as best we can as human beings, what happened here. What are the facts? And the assigned assistant DA takes those facts and he applies well-settled statutory and case law. And this process is an ongoing process in my office. We meet regularly. It'll be 2, 3, 4, 6 times even on a particular case, where there's a lot of give and take and debate and discussion among all the leadership in the office, myself included. Ultimately, there's a final recommendation that's placed before me, and I'm the person that makes the final decision on whether or not a crime has occurred here, and if so, who should be charged. This is the case for all death investigations. So when there's a homicide, not a police officer, there's a senior prosecutor that goes out to the scene. There's a team of investigators. In fact, it may not even be as many as we see in the fitted team, but there's a large number of detectives that are joined by a prosecutor who is directing and leading the investigation with the assigned sergeant detective and his team. And ultimately, the charging decision is made by the district attorney, not the police department. So nobody gets charged with homicide unless the district attorney says so. That doesn't happen everywhere in the United States, but I will tell you that, more often than not in those jurisdictions, there's a lot of fighting going on between the police department and the prosecutor. The police officer is saying, hey, we have enough here, charge this guy. And the police are saying, we don't have enough here, we're not going to charge this guy, and they fight. This is a good system. We rely a lot on their investigation, but it's our job to evaluate it and make our own independent judgment on that. So there aren't 2 types of investigations. There aren't one for police and one for civilians. The process for investigating fatal police-involved shooting is nearly identical to the investigation of every criminal homicide case that we do. In every death investigation, police involved or otherwise, as I mentioned, only the DA can authorize charges. And we don't level such an ominous charge against anybody who lives in our city or our region, charging someone with homicide, unless we have identified the responsible party and we can prove that the use of force was greater than reasonable under the circumstances. Been a lot of talk about the grand jury in the wake of Ferguson and the wake of Staten Island. So let me talk a little bit about that. Here in Massachusetts, nobody can be charged with a serious crime unless the grand jury says so. So every case involving murder or assault or sexual assault or what have you, must go and be presented to the grand jury. The grand jury is a powerful tool to obtain evidence and testimony that otherwise would be unavailable. But we're not going to use the grand jury as a cover for our own judgment. That's what we were hired to do, to exercise our own judgment. So that the most appropriate use of the grand jury is when the conduct is obviously criminal. and charges are obviously going to be brought, and the case is brought to the grand jury to get to that next level of the Superior Court. But the grand jury is also useful when the facts are in dispute. So when there are two very conflicting versions of the case, everything is presented to the grand jury, and the grand jury helps prosecutors sort that out. And another excellent use of the grand jury is when evidence and statements are being withheld by people. You know, I've spoken out about the need for more evidence and more people to come forward when they know something about a crime. And oftentimes people won't do that, and there are sometimes valid reasons for that. They're afraid, but there's oftentimes the code of the street, and they won't come in. So the grand jury is a mechanism by which they must testify. They can't refuse to come into the grand jury. They can refuse to talk to the police, but they can't refuse to come to the grand jury. They can take the Fifth Amendment and say, I'm not going to testify because I'm not going to incriminate myself. But that doesn't even hold water. Some judge is going to listen to them and find out if they truthfully do have a Fifth Amendment right. And if they don't, they are going to be compelled to testify. And if they don't testify, they are going to be jailed. So the grand jury can be very helpful getting to the bottom of something when people are withholding evidence. But the facts in police-involved shootings are often not in dispute. The key question is, was the officer's actions reasonable? Did he face a threat that allowed him or her to exercise deadly force? So when we're analyzing these situations, when a police officer does use deadly force, and we are considering what charges, if any, to bring, the potential charges are these. Murder, in the first or second degree. That's the unlawful taking of a human life with a specific intent to kill without justification or excuse. Manslaughter is the unlawful taking of a human life through reckless conduct. In other words, you see a risky situation, you take it anyway. Or assault and battery by means of a dangerous weapon. In the case of a gunshot, that's assault and battery by means of a dangerous weapon. Obviously, the gun is dangerous. Once the bullet strikes your body, you have been assaulted, and that would be another potential charge that could be brought. So this is what we are considering when we are analyzing all the facts and we are applying the law to those facts. So proving a homicide case requires proving elements of these crimes beyond a reasonable doubt, a very, very high threshold in our society, as it should be. And proving that a defendant did not act in self-defense, that's an affirmative burden on the prosecutor. So we charge anybody with a crime. If they say, I acted in self-defense, and they put on evidence, it is the prosecutor's burden to prove that he did not act in self-defense beyond a reasonable doubt. Now, the use of lethal force in self-defense, this is the law that's given to us from years and years of case law and jurisprudence that has been handed down from our courts here in Massachusetts and the United States Supreme Court. The use of lethal force in self-defense is lawful if a reasonable person believes that he or she is in immediate danger of being killed or seriously injured. The question, and this is how the jury is instructed, so you imagine this case has gone to trial, there has been a homicide, the defendant has interposed a self-defense claim. The jury is told the question of how far a party may properly go in self-defense is to be considered by the jury with due regard for human impulses and not to be judged too strictly. That's what they hear when we handle cases where self-defense is used as a defense by the defendant. The United States Supreme Court has made some very specific findings with respect to the use of force by police. They said that the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with the 20/20 vision of hindsight. And further, they said, the calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. That goes back to 1989 in the case of Graham versus Connor, but the Supreme Court just affirmed that this year in another case. The American Bar Association has established a model ethical code for all lawyers, specifically related to prosecutors. They have said a prosecutor should not cause to be instituted, or permit the continued pendency of criminal charges in the absence of sufficient admissible evidence to support a conviction. So in any case that we decline to bring criminal charges, so again, let's look at those 8 police-involved shootings in the last decade. And in all of those cases, I concluded that the police officers acted with justification. All of those cases can be reviewed by the Massachusetts Attorney General and the United States Attorney for the District of Massachusetts. Now, when I've had those family meetings, some of them have gone reasonably well, a few of them have not, and people are upset. I don't agree with you, Mr. Conley. I am going to the Attorney General. I am going to the U.S. Attorney. I am going to get justice there, and they get very angry. And I understand that. Believe me, you've lost a loved one, and they are going to go to these other agencies. I'll be the district attorney. It'll be 13 years in February. We have never had a case where the Attorney General of the United States Attorney has overturned or taken charges up on any of the cases that we handle. The standard for charging, for me or our office, making a decision in police-involved use of force, was the officer's conduct criminal or was it non-criminal? Determining that an officer's actions were not criminal is not an endorsement of his or her actions or a finding that they were the best ones to take. My sole job is, after we know what the facts were, after we apply the law, did the officer break the law? Is his conduct or her conduct criminal conduct under Massachusetts law? Now, some of you probably say, well, you're too close to the police, how can you ever make that decision? I've heard that before. We've heard that all over the country. Just so you know, in case you care, in the last decade, I've prosecuted 17 police officers for all sorts of various crimes. By and large, in 2000 police department in Boston, not to mention Revere, Chelsea, and Winthrop, and the state police that work here. But I have prosecuted 17 individuals here in Suffolk County over the past decade. So nobody's above the law, police officer or otherwise. We make our decisions on the facts and the law. The use of lethal force in self-defense is not limited to law enforcement officials. Now, in the past 10 years, applying the same standards as we do in police-involved shootings, I have declined to charge 5 civilians who have killed other individuals because I concluded that they acted in self-defense. You may have read recently about a woman who was subjected by her former boyfriend to excessive abuse over a period of years. He broke into her house and was really giving her a hard time, backed her into a corner, and she stabbed him 1 time in the heart recently. He died. She had bruising and cuts and so forth on her. And after the police investigation and our investigation, I concluded, based on those facts, applying the law as it is given to me, that she should not be charged, and she has not been. And there were 5 other cases where we concluded the same. This is to highlight that we apply the same standard to civilians as we do to police officers. So even if an officer's use of force is not criminal under Massachusetts law, the officer may be subject to discipline within his or her own department. That's going to be up to the police department, not me. It's not a decision I make. It's not a decision I even opine on, although I will tell you, if I may digress a bit, you might remember when the Red Sox won the pennant. There was this is about a decade ago, A young woman was sitting on a railing. Police officer fired a shot, struck her in the eye. She died. The officer was reacting to someone who was behind her throwing bottles in his direction. So I don't know if he was disciplined, I'm saying that, but I did recommend to the commissioner at the time, I can't remember now who it is, stop using those firearms. And they have stopped using those firearms. I can make recommendation like that, but discipline, that's a police matter, not my matter, not up to me. It's up to the police. What do I do after we have concluded that in these 8 instances that the police officer will not be charged for using deadly force? Well, as I mentioned, I meet with the family. I meet with the family personally. Members of the FIDIT team are there. Members of my senior staff are there who worked on the case. And I explain to the family my decision. Oftentimes they're represented by counsel. And if they are represented by, or not, once the case is closed out, the entire file, lock, stock, and barrel, nothing withheld, goes over to the victim, to the deceased family. What we've been doing lately is asking people from the clergy, from civil rights advocates, youth workers, particularly youth workers, to come in right after we meet with the family so we can explain to them exactly what we just did. Why is that important? Because they talk to people. And you know, the Boston Globe and the Boston Herald is only going to report a tiny little part. They're not going to tell everything, explain everything the way we explained that in that family meeting. I then write a letter to the police commissioner or the chief of police if it was, you know, Revere, Chelsea, or Winthrop. It's a detailed letter that explains our findings. And so what were the facts? What was the law? What is my conclusion? And I release that letter publicly after I meet with the family. And I post that letter on my website. And if any of you are interested in reading about any of those 8 cases that I described, please go to my website and you can read every single letter and every single decision that we made. Finally, we open up the entire investigative file to media scrutiny.